last week is labor law in a nutshell. And today we continue with our series. Today I'm going to do workplace internal committees and also the forums and the processes that are involved. So maybe we have to recap from last week, maybe just to put us at a better place. So we said employment is a state when someone is being involved in a productive activity or in an occupation. This can be either full-time or it can be part-time, and this person is working on behalf of someone called an employer in exchange of money for compensation or payment. We say the legal provision or the thing that are binding in this relationship is the contract and the statutory provision. So both the contractual provision and statutory provision, they bind you. If you sign a contract, you are binding yourself, and also the law is binding. And then we said Section 22 and 23 of the Constitution, they deal with the freedom of trade and occupation, freedom of profession, and labor relations. So you have a right to choose the occupation and the profession that you are. So you have a right to employment and you have a right to labor relations. And then we said the statutes or legislation, they are formed by the Act of Parliament. So the statutes that are formed by Parliament in South Africa, they include the Basic Conditions of Employment Act, Labor Relations Act, OHSA, that's Occupational Health and Safety, and the Employment Equity Act, National Minimum Wage Act, and Skills Development Act. We say the treasures of statutes, those are special institutions that are created or they are formed by the law or statutes. These include CCMA, Bargaining Council, Labor Court, and other forums. So these are the forums that are formed by labor law or employment laws. And then we said in terms of labor law, if you are moving away from the judicial processes, now you come to a government executive now, talking about the ministries now. The ministry that deals with employment is the Ministry of Employment, also called the Department of Employment and Labor. Now we said it's not only the legislation or the law that governs what labor law is, it's also based on common law or case law. And then we said the case law is based on legal precedents, which is the judicial decisions from previous cases. So if there was a case that dealt, I made an example with retrenchment, then the cases of retrenchment will influence new cases. So the cases of retrenchments from last year, it will have an influence on how we interpret the following cases of retrenchment. So that's what we mean when we refer to judicial precedents. So today I'm dealing with committees. When I'm doing committees and forums in the workplace, I'm doing it in a more holistic way. I know depending on other workplaces, in other workplaces don't have all these forums, but I'm just doing what is most general. So in terms of the Skills Development Act and the Labor and the Employment Equity Act, we've got what we call the Employment Equity and Skills Development Consultative Committee. So this forum in other workplaces is only called Skills Development Committee only. So, which means that so this is a committee that's got employee representative. You've got people from the HR department and it's got people from management. So what they do, the skills development requires all registered employer. So the employers with an annual payroll of exceeding 500,000 are required to pay skills development levy and subsequently submit a workplace skills plan and an annual tracking report So what it means is that if you're an employer who qualifies for this, you must pay a portion of money, and this money it also goes together with a skills plan. This means that you must have a consultative section with the people in this committee and develop a skills plan of how are you guys going to develop the people in the workplace. So guys, the other thing that I've noticed, some employers, they ignore this. You find that someone was employed as a cashier a long time ago, and then is still a cashier or is still a receptionist even after 20 years. So that is wrong. There's supposed to be a skills plan to develop people in the workplace. Someone is not supposed to stay in one position. It's supposed to be developed. Even if someone is not educated, in that skills plan, it's supposed to tell exactly how many people need to be developed from which level to which level. And then it also goes with what we call Employment Equity Act. Because you find that sometimes we're targeting in a certain type of environment, maybe we're targeting black people because we were previously disadvantaged, or targeting female employees to develop them. So that plan must tell exactly what are the actions. So is the employee what learnership is the employer gonna do, and bursaries to make sure that people are developed. And it must also submit what we call an annual tracking report. So these submissions they are made annually to the relevant sector education training authority. So when I talked about SETAs, every sector, every industry has got its own. If you are in the financial sector, it's got its own SETA, and then if you are in the energy industry, so it's got its own. So each and every SETA must make sure that it supervises the workplaces in that industry to make sure that they comply with the Skills Development Act. So that is the forum that we have under Skills Development Act. And then we've got another forum that we call is under Labor Relations Act and Basic Conditions of Employment Act. So we've got national wage negotiation and consolidation and consolidated conditions of employment. So you find that in an industry, for example, the chemical industry where I belong, at a national level, we negotiate wages. So the members, the employers' organization, which is the employers, they group together and form an organization. And then you've got trade union, which is they group together as well, and they are normally called organized labor or trade unions. So they negotiate in that industry for the employees that are represented by this union. They negotiate the wages every year. It's normally annual, depending on the agreement, but it's normally every year. And then at a local level, we've got what we call a shop steward committee. Shop steward is what we call as a trade union representative. So they are also called shop steward. So the activities of a shop steward in the employment is just to attend consultative meeting with management. So in this meeting, they represent employees on labor issues. They also perform any other activity that is assigned to them by the law. For example, some of the things they have to make sure that the employer complies with the Labor Relations Act, and they have to report it. If they can report to a labor inspector if they find that the employer is not complying. So they do a lot of things. Those are shop stewards. So there's another committee that we have under Occupational Health and Safety. So we've got Health and Safety Committee. The Health and Safety Committee derives its power from the Occupational Health and Safety Act. The members, health and safety representatives. So people who are appointed in the workplace to be health and safety representative, they go through a training so that they are equipped to develop, to represent people. So the activities they do is mostly to monitor, inspect, consult, and report on all health and safety related issues in the workplace. So, for example, if you are working in a mine, the health and safety representative should report any dangers that he can see, anything that can put other workers at risk. So he's supposed to report them and also advise. So he's representing employees. Another forum that is also important for us to look at is what we call is under Pension Funds Act, and also given its or derive its power from pension fund rules. So it can be a pension fund or a provident fund, but they normally have what we call a local advisory committee. So this one is composed of employees who are members of a pension or provident fund. So some of the employees will be selected to be a local advisory panel. So with the activity they will do is to act as a bridge between pension funds management, and its members, ensuring that members' voice are presented and considered. So if we select you, say Hlahla and Mtu are part of our local advisory committee, the decisions that are taken regarding our pension funds, the investment, and everything that are signed, they need to make sure that they represent us in the meetings, to make sure that our money is spent in a right way. Also, just to make sure that we get information about what's happening with the pension. So I know this one of a pension fund is some people don't record, they feel like it's not part of labor law, but there's a lot of intersection in the workplace between the pension fund and labor law, because it all these they deal with employee, and they deal with the money, they deal with employees' resources, and it also deals with the employer and employee. So it's very good sometimes to understand what the pension fund local advisory panel is all about and who are the people, even if it's not members of a trade union. Because when members come to you and ask questions, then you can advise them, or you can send them to the relevant people. So that's very important to know. So now I've dealt with committees, guys. Let me just wait a bit and just try to get if you guys are still with me. Any question or
questions based on your
Sure.
explanation you just explained now?
Sure.
The first answer that the first question is, you said it's against the law when an employee has spent more than 15 to 20 years in one position. And then let's say now you feel like you want to take it up. The first step that you need to do is to lodge a grievance complaint with the company regarding that, or you just write an email to HR or your manager explaining how they are treating you or why they don't give you opportunity so that you can be a better person, because it seems as if you are an asset to the company. You spend 20 years, but they don't recognize you as an employee. The second question would be based on a provident fund or pension fund. You get companies that they say they don't pay provident fund or they don't pay pension fund, and then that's it. So if you are saying that as an employee can query that, maybe with the Department of Labor or with the PFA, I'm not sure. How does one query pension fund or provident fund to the company? Those are my two questions.
Yeah. Okay, thanks. And maybe let me start with the one of skills development that I talked about earlier on. So the employer, if employer is qualifying with this exceeds that 500,000, he's required to put this money. This money is for people's development. So what happens in our workplaces that we see is that the employer, they don't develop people as they're supposed to, and sometimes people, they don't know these things, you see. So it's very important maybe to consult, to put a grievance with HR, to consult about this, why we're not being developed. For example, in my work, I'm not the cases of development. They are not one of the cases that are very, what can I say, that people normally fight for. People can fight for salary increase and stuff, but for skills development. So I once had an issue in my workplace, and then I did complain. I put a grievance about this. And then also one helped another guy who also was complaining about development. And then the company assigned him a program, a computer training program, because he was... So it's just that sometimes we don't know about these things, but we're supposed to put a grievance and complain that why we're not being developed. You see. Of course, there are situations where the employees themselves, they don't take forward what can I say? They don't take forward the mandate to inquire about these things and complain. You see. So it's good to get an advice and also to complain. Sometimes when you ask about these things, that's when you know the right processes. But I can tell you the truth that some of the employers, they don't really care about people. And it's because people maybe they don't know that you can actually challenge. And also another thing is that you can also put what we call unfair labor practices as well. If the employer is doing it to other people and they don't do it to you, they don't develop you, that one is called the unfair labor practices. So in terms of the Skill Development Act, the employee is required to have a skills plan and is required to develop all the people. So we can discuss about this on the side, so that because it will vary from the company to company, the type of training that are required. For example, for us who are in the energy and chemical sector, maybe I might not need the training on financial issues, but they have to train me on things that are relevant in my career, that are aligned with my career. So it's one of the things that I really want us to, as to really look at. I myself I only know 2 cases that I've been part of. I don't have much information on this, but I do know for sure that you can put a grievance and you can inquire about this. Okay, with a pension fund, I'm not sure about the pension fund, but I know that I know about one case of a pension fund adjudicator. Some employees, if you're a permanent employee, the employee is supposed to pay you, supposed to pay pension fund for you. But if you're a contractor, I know that certain employees, they don't pay for you. You have to pay for yourself. They just pay you all the money, all your salary. But if you're a permanent employee, you're supposed to belong to a pension or provident fund. I think we can look at that case too, and then see what the pension fund rules or law says. But I believe that if you're a permanent employee, you should belong to a pension fund. So yeah, the complaints are sent to a pension fund adjudicator. What can I say? The complaint body that for the pension or provident fund that we complain to is called a pension fund adjudicator. Actually, the process is easy because you can submit your complaint online, and you submit all your complaint and write a statement, and then they will contact you, and then they investigate you, and they will make a finding. So it's a pension fund adjudicator. So, but what I was saying is that certain employers, if you're a permanent employee, from what I know, is that you should belong to a pension fund or provident fund. They should pay. And also if you are a contractor, the employer is not required. If you're a temporary employee, the employer is not required to pay for you to join the provident or pension fund. So which we have to look at each case in its own merit. But if you're a permanent employee, you should. And remember, if in Africa they are taking chances. I'm telling you the truth, especially in temporal employment services, where you're employed maybe for a short period of time. They're taking chances in a lot of things. So even if they don't pay you, there are certain things that they should pay. Things like a UIF and all those things they're supposed to pay. But what we're going to do as time goes on, I want us to go to these issues one by one and say, okay, let's talk maybe today about UIF, let's talk today about pension fund, let's talk today about skills development. Sasha, are you guys there?
Yeah, I'm still here. I heard you, and then you've covered my next question, where you said maybe we'll have a day where we can have a discussion on provident fund. How does it work? How is it calculated? Because sometimes you get companies, maybe they don't calculate it at 7.5%, they do it on 6.5%, some at 5%.
Yeah.
So I think you've covered my other questions. You can carry on my side.
Okay, thanks. So they also, I dealt with committees that we need to know about, even if you don't know much about, but as we are representing people, you just have to have an idea so that you can send people to the right places, or you can ask information from the employer that, okay, if someone wants to know.
To notice that when I'm saying compulsory, I mean those that are specified in the labor law legislation. Yeah. So we're just only doing today just a brief overview. One of the programs or process that we have is the disciplinary code and procedure. Every workplace must have a disciplinary code and a procedure. This is for correction and discipline. Remember, disciplinary is not just about punishing. It also has to do with correction, counseling, and discipline. So this code is specified, or the code that the employer should follow on the Labor Relations Act Schedule 8, and it's also find it in the internal codes and policies of the company. So it's very important for the company to have a disciplinary code and procedure, so that there's a process that we know, where everyone knows which process to follow. There's also what we call a grievance procedure. So the grievance procedure is all about a workplace dispute resolution. When an employee has got a concern or work-related complaint. So remember, the Labor Relations Act does not mention specifically grievance process. It just says that there must be a way of resolving disputes and complaints in the workplace. So the employer normally have a grievance procedure. And depending on how complex the organization is, some organization is just to put your complaint in writing and then you get an answer in writing. Some have got a form that you must fill, and it's got different steps that you must follow. Now we're starting from the basic steps. For example, maybe you'll start, step 1 will say talk to the person who's maybe giving you a problem in the workplace. Maybe someone is verbal abusing you. Maybe the first step will be to say, can you please talk to that person first? If you can't talk to that person, then you move over maybe to the supervisor. If you can't talk to the supervisor, or the matter is not resolved, you move over to the management or an HR personnel. So yeah, until the complaint is resolved. If it's not resolved, then you can lay your complaint maybe to an external party. Maybe it's the CMA or Department of Labor, depending on what the issue is. There's also a program called Health and Safety Induction in dangerous workplaces like the mining, factories, or working in a plant. This one is compulsory. In terms of the Occupational Health and Safety Act, the employers are required to give awareness and information about the hazards and risks in that particular workplace. So this one is compulsory for anyone to do, but I always encourage that it must be done in all workplaces, because every workplace has got its own hazard. If you're working in a restaurant, there are hazards in the restaurant. If there's a fire, what are you gonna do? If there's a stampede, what are you gonna do? If there's a spillage of cleaning chemicals, what are you gonna how are you gonna handle them? So every workplace, if there's a fire, how are you gonna direct the customers? Where is the emergency exit? Where is the master point? So it's very important this in any type of workplace. All right, so I'm gonna move over to non-compulsory. There's non-compulsory programs. They include the onboarding workshops. Just these ones are just general, where you're told introduced to the work environment. It's very important, because the other work environment, you are just put into the job and you learn everything on duty, which is not right. There should be a dedicated day or time where you only come for induction and you are properly introduced to the type of workplace that you're gonna use. They show you everything that you're gonna be needing. They show you the facility. There's also what we call a toolbox talk. A toolbox talk is very important, because you can discuss a lot of things. You can discuss about the activities of the day. Is very important. And then there's also what we call employee wellness program. Say, for example, if someone is suffering from depression and stress in the workplace, so what actions must that person take? So it's there to assist the employee, to make sure that the employee is well taken care of, and assist the employee to make sure that his wellness or well-being is protected, and the employee is healthy. You see, if someone is struggling maybe from drug addiction, the employee must provide mechanisms. So as much as it's not compulsory, but these are very important. In fact, in other workplaces, these are even compulsory. It depends on the type of workplace. So there's also what we call the social and team building programs. Normally, employees, maybe some of them once a month, they provide services to the employee to make sure that they have got events for socializing and team building. Maybe things like end-year functions, things like heritage and day. So all those things are meant to enhance the relationship between workers. There might be also other programs like performance management program, where an employee is involved by aligning the career of an employee and activities to what the organization want to achieve. For example, maybe at the beginning of the year they might have a meeting where they set a score that we want to achieve this score, and the manager and the employee, they agree, and then maybe they review it in midterm, and then there's a final score. They review it maybe at the end of the year, and if the employee meets those scores, then he get allowances and bonuses. So it's also linked to rewards, but it's also linked sometimes to promotion. So performance management is also very important in the workplace. There might be other sessions like general meetings and feedback sessions. So all those things are very important in the workplace. So you just have to be aware of what programs your workplace have, and we can even recommend certain programs as employee representatives. So thank you so much, guys, for your time. Just want to ask if you've got any question.